Good evening, everybody. I hope you are all doing well, and wherever you are, I hope the temperature is not too hot or too cold. It looks like we're kind of at the end of the winter season. I know here in Atlanta, it's in the mid 50s. It's kind of teetering between the mid 50s and mid 60s. So I'm hoping that our our cold weather is gone because I'm ready for the spring. So anyway, I hope that we're all doing well. Obviously, there's a lot of stuff going on in the world, the American political body, as well as in Social Security. There's obviously been a lot of talk about cutting staff. The last I heard is that they're talking about cutting about 7,000 workers from Social Security, reducing the number of regions from 10 to 4. My take on all this is that this is a move to make things more efficient. Social Security has been really inefficient for a long time, and I think that certainly their efficiency would be a good thing. The problem is when you do this using a hatchet, which is what they're doing, it's going to be a lot of short-term pain, and the pain may be short-term, maybe a year, maybe 2, 3, 4 years. I know a lot of people have emailed me that Commissioner O'Malley, the former commissioner, thinks that there's going to actually be an interruption in benefits in the next 60 to 90 days. Don't know about that, but certainly Social Security has been understaffed for many, many years. Cutting it further, we'll see what happens, because I know that there's a lot of stuff that can be computerized, but it takes a while to get that done, and not to have human backup. It's going to be interesting. It's going to be interesting. So anyway, I'm sure there'll be a lot of questions about that. Let us go to the first question here. Blue City Garage, who says 3 years ago, he quit work. Make sure everybody can hear me okay. Looks like you should be able to hear me. If you can't, let me know, but I think according to my end of it, it looks like the sound is pretty good. 3 years ago, Blue City quit work. His initial claim has taken 19 months. And realize when I started doing this 30 years ago, initial claims were taking 3 or 4 months. And now we have situations where they're taking 19 months. That's a long, long time. That's, well over a year and a half for an initial claim. And no money coming in, difficult. Had a consultative evaluation about a month ago. Anxious this may go past the 5-year insurance rule, the date last insured. Will this affect me? He says, I go to a specialist regularly. Most of my objective evidence, the EMG, nerve conduction study, MRI, CT are 18 months or older. Are they too old? An MRI of the neck in August of 24. So first question is, your date last insured, it may run, but the thing is, if your onset date is prior to your date last insured, you're fine. In other words, if you filed your application, let's just say in 19 months from now, previously would have been, let's say, sometime in 2023, let's say October of 2023. If your date last insured was February of 24, as long as your onset date is before your date last insured, you're fine. The problem is, of course, if you get denied and have to refile, all this time is using up. There's no tolling of the date last insured. So if you are, let's say your date last insured is February of 2025, and you end up getting denied sometime in, February of 2026, and then you try to reapply, you are basically what they call res judicata. You cannot ask for disability prior to the date of the unfavorable last decision. So it really reduces your options. So one of the downsides to these long delays is that, if you get denied, you try again, you may not be insured. So you need to know what that date last insured is. I've always been of the belief that if you apply for benefits and you're denied and you want to reapply, wait 6 or 8 months or a year to see if something changes, because realize if you reapply right away, then nothing has changed. And so the earliest date you can use as your onset is the day after the unfavorable hearing decision. So if you got denied at a hearing and then you reapply, it's going to go back to the same judge. Nothing has changed. Now, if your age category changes, after that, that's helpful. If you go from 49 to 50 or 54 to 55, now maybe the grid rules apply. Or if you develop a new medical problem, that can help. But other than that, it can sometimes make sense to wait. However, if your date last insured is run, you can't, and you may not be able to refile. You're going to have to pursue an appeal. So it just makes one less option available through no fault of your own, but just because of these delays. Now, he also says, I go to a specialist regularly, objective evidence, and this is a very smart question. EMG, MRI, CT are 18 months or older, and that is a problem because, again, you get to a hearing and now those reports are 24, 30 months old because, again, you're just at initial. It's going to be another year and a half to 2 years before you get to a hearing probably. So now you're looking at MRIs that may be, 2, 3, 4 years old. So you kind of need new ones. Now, again, those old MRIs would talk about your condition as of onset, but of course the judge is going to want to know what's going on now. So yeah, it is a problem. And again, these are issues that because of the delays puts you behind the 8 ball, and that you've got to now find a way to pay for new MRIs so that the judge would have evidence of your current situation. Because yeah, a judge could very easily say, well, you don't have anything new, so how do I know what's going on? How can I assume that you are still disabled? That's a problem. Look, I had a hearing today, and a judge did something what I thought was incorrect. And we'll see, there's some things going on that hopefully will make it turn out okay. But this particular situation, a gentleman had applied for benefits, and shortly after his onset date, he went to a doctor who told him he needed surgery. So, he had already tried in the past while he was still working conservative treatment like epidurals, and he had tried physical therapy and chiropractic and all that, and none of it worked. So he keeps working, fought it as hard as he could. He stops working. Shortly thereafter goes to see a surgeon who says we need to do surgery. Well, and then the surgery has not happened because he has some insurance issues and some other issues. So the judge was like, well, I don't see any medical source statements. I don't see any functional capacity evaluation. I'm like, well, yeah, because he needs surgery. No one's going to do a functional capacity assessment when somebody needs surgery. I mean, that's the next step. This is not where there's other options other than surgery. Well, if we don't have one, I can't grant. Like, what are you talking about? So, I mean, again, I can see grounds for appeal if she denies the case. Again, there's some other things going on that I may be able to pull this out of the fire, but this just shows you, this is just an example, like I was talking about with the dates of the MRIs or the date last insured, where the long delays in processing have a negative impact on claimants because, they can't do anything while they're waiting for a disability decision or a hearing. And, it's not your fault that it's taking 2 years, but you're paying the price for it. So Blue City, I think that, the date last insured would as long as it's before the onset date is okay, as long as it's before the date last insured. You may not have an option if you're denied to refile. So this may be your one bite at the apple. And number two is that, yeah, you're probably going to need to get updated objective tests so that the judge would have an idea of what your situation is like now. And, that's a lot to ask of somebody who's got no income coming in to pay for objective tests like MRIs and EMGs. They can be expensive. Ron Kimbrough says, I filed for SSDI in January of 24, it's denied at first, and I appealed at Recon, and you won. Good. The CE examiner put the onset date of August of that year. So I'm guessing August of 2024, and looking to get his first payment. Should have had an earlier onset date in Texas. Under a year was great for treatment for Texas. Yes, so basically you had an approval, but they changed the onset date. Now, if they changed it by 7 or 8 months, you may not, that's hard to say you should appeal. And I've got a couple now where the onset it was changed by 30 months or 25 months. And yeah, I'm recommending that we appeal because that's $30,000, $40,000, $50,000. But we're going to see more of this where Social Security is going to approve cases, change the onset date to cut out past due benefits. And it puts you in a really, really difficult situation because if you appeal the onset date, you can't just appeal that. You have to appeal the whole thing. And so you can end up in front of a judge who approves at 15%, and you've already been approved as of August of 24. Now you may get a denial, then you're in overpay status. Doesn't happen very often, but it could happen. That's the risk. So yeah, those are some of the issues that we're going to be dealing with, I think. But again, you might, and I would also wonder, if is the reason why they changed the onset date because you changed age categories. You went from, 49 to 50 or 54 to 55. In that situation, I might be more hesitant to challenge the onset date. But if there was no good reason for it and there's evidence showing that your onset should have been in January, you might talk to an attorney about challenging the onset date. Okay, SA says, I saw a spine surgeon. I'm going to get another epidural and then a spinal fusion. What is suggested? I filled out an ODI. Score was 38. Will this hurt? I'm not sure what ODI, I think I know who this is, but what is it? I'm not sure what an ODI is. And I think that the answer I gave you, I believe by email, was that, Social Security is not going to accept, or they're not going to be bound by decisions or, assessments, a moderate assessment or a 38 score on some test that is not binding to Social Security. So if it was a different type of disability claim or a different standard, then it's part of the picture, but it's not going to bind Social Security. So I wouldn't get too worried about that. And again, the bigger picture is your age. And if you are who I think you are, you should be fine on that. And the underlying MRIs, which are strong. So, having one assessment by somebody using a scale that is not binding on Social Security wouldn't really bother me too much. Glenn says, Martin O'Malley, the former commissioner, says within 3 months, Social Security payments will be disrupted. Trump and Musk are destroying Social Security. Mr. O'Malley did in fact say that he thinks there may be a disruption in payment because when you lose a bunch of people and you have a lot of senior people or experienced people resign, there very well could be interruptions in service. As far as the payments, a lot of that is automated. So I don't know that ongoing payments are going to be a problem. Where I see potential issue would be processing of favorable decisions and starting payments, or if you have a problem, trying to get somebody on the phone to fix it. Mr. O'Malley's opinion is, and I think there's some support for this, that, as kind of as I mentioned at the beginning, you start cutting a lot of experienced people without something to replace it with. It's other people or computer systems or something, then there's going to be gaps. And you're going to have people in Social Security trying to wear 5 hats to deal with things that, are just, they don't have the time to do. So, things are going to get lost, are going to be left behind. What I fear is, and we've already seen with the gentleman talked about, he had waited 19 months. What happens if the disability process from start to finish, before you get to a hearing, becomes 4 years? Now it's 2. I had one the other day, it was 3 years. What if it's 4 years? You're expecting people who cannot work to wait 4 years, 4+ years for a chance to talk to a judge. And then, when you get in front of the judge will say, well, there's no updated medical records. Yeah, because I haven't worked for 4 years and I can't afford it. What is that going to look like? So yeah, those are some really very, very valid concerns. I think we need to take it one day at a time. I know there's some litigation that's been filed to block Social Security from these cuts. We shall see. But this is certainly a concerning time for Social Security. And I would tell you that, if you're on the fence about applying, probably the sooner you do, the better, because the more you get these cases in process, that's one less thing to be a problem. So, I'm telling folks that call me, if you're thinking at all about it, go ahead and do it, and if you want me to do it, I'll do it for you. We'll get it done quickly, get these applications filed, try to get these cases approved on the record before, the poop hits the fan, because it's, it could be very, very interesting times coming up. Right. Well, this is exactly what Kevin's saying. What's going to happen? 5 years for initial, 7 years recon, 9 years for a hearing. Look, I mean, the VA, the way they do it is they decide somebody's disabled. They give them like a 30% or 40%. Then you appeal it and it goes to 50%. And it can take 7-8 years to get to 100%. That may be the model they're thinking about. I don't know. But yeah, it's going to be a real problem. At the same time, I know the initiatives to catch the really strong cases early, get them approved without having the medical review. So there is certainly an effort. Again, if I had to guess, I would think that there is an effort. There's a thought that a certain percentage of people are clearly disabled. Let's get those people approved quickly. There's a certain percentage of people that are, just there's no way they're ever going to get approved. There's nothing you can do to stop them from applying. Then you got a lot of people in the middle that, are the ones that I'm taking to hearing that, depending on what the evidence says, may or may not be disabled under Social Security's rules. It's unfortunate to say, but those people may be, waiting a lot longer. Kevin's been waiting 2 years, and he says it's horrifying for people applying now. Could be. Yeah, it could be. I mean, it could be a really difficult thing. All right, Jennifer, how are you doing, Jennifer? Hope you're doing well. It's good to see you back. I'm on a long-term disability. I've been since March of 23. Will I repay LTD long-term disability when you're approved? Only got it for 5 years, and I've been waiting 2.5 years. Been in recon for 10 months. Every month that you have both Social Security payments and long-term disability, you have to pay them back for. So if it's the 5-month waiting period, you don't pay them back that because you never got it. The part of your benefit that goes to pays your attorney, you don't pay them back that either. So in other words, you don't pay back long-term disability insurance company money that you did not receive. So the funds that were not paid because of the waiting period or funds that were paid to your attorney don't get paid back. Everything else does, as long as there was a double dip, as it were, between long-term as well as Social Security. Hoping for decision. I am too. To get denied at recon, is that when you would file for hearing? Yes. Or when you get, yes, you basically would request a hearing within 60 days of the recon denial. And I will tell you flat out, recon has a low approval rate. At initial, it's about 35%. Recon's 15%. Hearings 50%. So recon goes back to the same people who denied you at initial. They're going to typically deny you again. Many people feel like it's just Social Security's efforts to, just basically delay the process even further. So, if that's the case, it's a big waste of time. Charles has one of two. Okay. Hello, 62 years old, 62 years, 8 months old. My last day of working was 1/21/25. Suffering from bilateral polyneuropathy, which is very painful. It's diagnosed by an EMG, spinal stenosis, herniated disc, diagnosed with an MRI, have severe problems walking, standing, balancing. Also have hypertension, diabetes. He's insulin dependent, anxiety, major depression disorder. Been on meds for 10 years, been seeing a psychologist over 2 years. Can I collect SS for social retirement? I'm waiting for decision. If so, should I apply for both at the same time, one before the other? A 44-year work history in the steel industry. First of all, you have a winning case based on that. And yes, you can apply for both at the same time. So basically, you would apply when you apply for disability at retirement age, you have an option to click a box that says, I also want to file for retirement. That would get the money coming in right away. Then if you win disability, you would get the difference between the early retirement and full retirement, which is equal to disability. So let's say your early retirement, pick a number, $2,000 a month, full retirement's $2,500. So you'd be going after that $500 a month extra. And so if you win, which I think you will, your disability case, it'll be $500 times however many months you were waiting. I will tell you, in all honesty, that will make it more difficult to get an attorney because the attorney gets paid 25% of past due benefits. $500 in a case like this, especially, it's probably going to get approved early. $500 times 7 or 8 months, then you factor the 5-month waiting period in. So you might be looking at 2 or 3 months. Your past due benefits may be $1,500. 25% of that, not a whole lot of money. It's going to be $300, $350. So you may have a hard time finding an attorney to take your case unless you were denied at initial. Because again, if you have a 2-year wait and you're looking at $500 a month times 24 months, that's $12,000. 25% of that is $3,000. That's probably worth an attorney's time. But if I was looking at a case like this with the facts as strong as they are, I would say this is likely a case that's going to get approved early. I would tell you, if you contacted me, go ahead and apply. You'll probably get approved early. If you were denied, then I would be more than happy to take a look at it. Because again, you just, unfortunately, the way they structure the fees, that attorneys just can't do this for free, and that's in essence what's going to happen, I think. And the good news, though, is you'll probably get approved early. So I think that is the good news here. But I think based on what you're telling me, then I think, Charles, you have a winning case with all those things. Certainly, if you were 57, there was no retirement at issue, I would say I would take that case in a heartbeat because it's a winning case. But because you're about to take retirement, it makes it a little more difficult to say that I would take it just because there's not enough, the cost of managing a case would be more than what I would receive. So that's just my take. Others may feel differently, but that's how I would look at it. All right, Eunice Sala. Thank you for your information. My question is if I have a problem with my disc for 20 years, but it's now worsened, should I tell them about the MRI I had done before or not? You're 54 years old, have a work history of 30 years. You work as a sailor. Eunice, I would say that generally speaking, when you apply for disability, they're going to look at the medical records going back, certainly to the time you stopped working and maybe a year before that. I do think that, and you make a very good point, that if there is evidence showing a long-term problem, like long-term disc issues, that is relevant. Again, it's not determinative because you were able to work past that, but certainly you can use it to show your condition has gotten worse. You can also use it to show that you worked through a painful back problem, that you were basically, have a high pain threshold, you're willing to work through it. So I would certainly, if I had it, I would submit that other MRI's background information because I think it helps tell a story. And if you've followed me for a while, I'm a big believer in claimant narratives. What I mean by that is you want to tell your story about how you came to be disabled. And part of that story is your long work history. Part of that story is your willingness and your ability to work through pain. Again, like my client from today, he had, before he stopped working, he had 2 epidurals. He went to chiropractor. He went to physical therapy. He did, he had, I guess let me say epidurals. He had, other types of massages. He did water therapy, things like that. He lost weight. All these things show that you are motivated, that you'd much rather be working. So I think that, part of your narrative, Eunice, is to show that, you are willing to work through a certain level of discomfort, but it's gotten to the point now where, and the new MRI would show this, that, you just can't do it anymore. I would also tell you, given what happened to me today, if at all possible, if you can get one of your doctors to complete a functional capacity assessment, that would, certainly satisfy some judges that your capacity to work has been greatly reduced by, specifically by your impairment. And specifically, I mean, how you're sitting, standing, walking, or need to take unscheduled breaks has become more significant due to the decline in your condition. Okay. Jennifer said she's 55 now and is applied for SSDI at 53. Realize this is one of those cases where Social Security may look at it and say, we'll approve you as a 55. Well, now you lose 2 years of benefits. Do you go for that? Or do you say, I'll take what they're giving me, or I'm going to fight it? And the risk being that you may get turned down. Now, again, my feeling is that if they've approved you at the administrative level, is it really likely that the judge is going to find you not disabled at all? The real risk would be a judge says, I'm going to do the same thing the state agency did, but probably you aren't going to get denied. But yeah, if that's the risk of when you apply at 53 or 53 and a half, that you may get approved, but all your past due benefits go away. Michael Robert Jennings. If a claimant elected Medicare continuation pending appeal, they need to pay back the Medicare. I don't know. If you win the appeal, is Medicare retroactive based on the previous denial for a CDR? I think that, I don't know. I don't deal with Medicare issues. I'm assuming that if you had Medicare that is later found to be not available to you because your disability got cut off, then Medicare might very well come to you and ask you to repay whatever they paid out. But I do not know. I suspect you could file bankruptcy on that. This might be a question that, somebody who deals with Medicare issues, elder law person might be, it's just not really within my ballpark. So I would probably tell you an elder law attorney might know. There's I'm sure there's people out there who would know, but I just do not know, unfortunately. Okay, if you win SSDI more than 29 months from the past since onset, you get retroactive Medicare is a 20 months once a lifetime. Well, I mean, if you get disability, you are, after the 5 year waiting period, you become eligible for Medicare 24 months after your first eligibility for payment of Social Security. If you are found not disabled and you lose benefits and then you reapply and get approved again, I think that that same, although again, this is not something I see, so I'm just telling you what I think. I think that you'd have to wait another 25 months. I don't think that, unless the benefits were found to be ongoing, but if there's a gap there and you have to start over again, I think that you would have to wait again for Medicare. Now, if you reapply within the extended period of disability, maybe there's some different rules. I just don't know. That's just not something that I ever have dealt with. So I don't want to lead you wrong, but I don't know. Okay. Can a disability lawyer, Michael has another question. Can a disability lawyer take a CDR when continuing benefits are declined? Does it matter if Medicare was declined pending appeal for the attorney? What you're asking is because when you get a CDR, and a CDR is maybe the wrong way to, when they move to terminate, it's part of the CDR process, but it's an action to terminate, and you choose not to have benefits continue, disability benefits continue, then those benefits begin accruing while you're waiting for a resolution, either reconsideration or hearing. So at that point, an attorney could take the case and say, well, I'll get paid on past due benefits, because there are past due benefits. If you elected to have benefits continue while you wait, no past due benefits, therefore no attorney is going to take it on a contingency. So again, the Medicare part would not impact me, but if I saw somebody came to me and said, I'm having a termination case, I've elected not to have benefits continue, and it looks like a strong case that's winnable, and I've done this, I've taken a couple of these, take the case, you win, I get paid my contingency fee, so it makes sense economically for me to do it. So the Medicare part really does not impact me. That does not. This is only having to do with Social Security. They're two different systems, and there's no offset to my knowledge. So if you end up owing money to Medicare, but again, if you're awarded, if you win the notice to terminate, then the Medicare remains intact during that whole time. Okay. From the lawyer's perspective for pay, does it differ from original claimant benefits pending appeal, received pending appeal or decline? Does it matter that Medicare pending appeal is declined? The Medicare part, no, because I think that's going to be because Social Security was declined. I think it's, again, not, that would not dissuade me. As far as whether when I look at a case, I'm looking at a case where the person's never been paid benefits versus a person who was paid now gets cut off. If anything, the person that was cut off that was approved for benefits, if there is evidence that shows that that person's medical condition remains disabling, many times that person to me would be a more attractive client because they've already been found disabled. And now Social Security's made a decision that they're not, can I argue that that was a wrong decision? Now, it kind of depends on why they were cut off. Did they go back to work? Was there some sort of medical improvement? What exactly is the reason? So it's kind of a case-by-case situation, but neither one is both. I'm going to look at either of those cases based on the merits of the case and whether I think the evidence is strong enough for me to win. And obviously, the factors I look at are age, the medical evidence, that sort of stuff, work history. Has there been any kind of work while the case is pending, that kind of thing. But it's just going to it's going to really depend on the individual situation. How does disability lawyers future look now that some are going to quit doing this and move on? My thoughts. So what you're asking is, if disability is completely changed, is that going to drive people out of the business? It may. I think that we're going to have to wait and see whether these delays start to impact cash flow, because obviously I've got enough cases where I'm trying 10, 15, sometimes 20 cases a month. And so, you don't get that many decisions every month, but, there's enough to cover my expenses and so forth. Well, if all of a sudden I'm starting to see, cash flow cuts in half and it's taking twice as long, yeah, it's going to be something I'm going to have to make some decisions on. You know, we're just going to take that as it comes. I mean, I think that in my firm in particular, we do workers' comp in Georgia. My wife does that. I've also have done bankruptcy for years. I've got another attorney who does that. So for me, maybe I pick up the slack with some other practice area. But yeah, I think that the cash flow in any business has got to make sense. And if delays mean cash flow becomes a problem, then it could cause people to either reduce the number of cases they take, become more selective, or get out of it entirely. And of course, if people get out of it entirely, that's more business for those of us who remain. So we'll just have to sort of see how that plays out. Trish Wade, hello, Trish. You are a regular. Good to see you here. JTL, very concerned about what might happen after what Barton O'Malley said. I would lose everything. Is there anything we can do to get prepared? My sense has always been that, Social Security, look, the AARP is the big lobby group that represents people who are on Social Security, retirement Social Security. So if they start messing around or checks stop coming for disability for Social Security recipients, it's going to stop coming to retirement recipients as well. They're a big lobby and they're a big voting group, and I promise you, I know the AARP is already telling people to contact their representatives. So I suspect that there's going to be a real concerted effort not to have checks interrupted, because if there's going to be a real hue and cry. And obviously, the president is not up for re-election because he can't, but your senators and representatives are. So I would certainly tell you, in terms of preparing, is to let your elected representatives know that you are hearing, and tell them. Martin O'Malley says he thinks there's going to be interruption of benefits, and just tell them that I'm telling you, Mr. or Ms. Representative, that would be a disaster, and I want to see you do something to prevent that. This is your job, is to represent me, and Social Security. We cannot have the most vulnerable among us, without their lifeline, without the money they need to survive, that you paid into the system for, and you're relying on your government to provide to you. I think that's the message that needs to be sent. And I suspect it's already being sent and heard. And I suspect a lot of representatives of both parties, but especially Republicans, are realizing that they cannot afford to see a situation where retirement or disability payees are not getting their money. So I would be surprised if it happened. I disagree with Mr. O'Malley, Governor O'Malley. I don't think it's going to happen, but who knows? But I don't think that would happen. I think that would be a real political nightmare for people who do have to run for re-election. Angie Vasquez says, I applied for disability in 2023 and for a job. 3 of 24 tried it and failed. 6 of 24 made about $15,000. Also in 24 did some SE due to financial need. 1099 was $15K. After expenses made less than $5K, will this cause denial? Well, basically, they look at, first of all, there are two things that come to mind. One would be, you could very likely argue these are failed or unsuccessful work attempts, no matter what you made. And if you made more than SGA for certain periods of time, you could ask Social Security to consider it part of your trial work period, because trial work period you become eligible for that as of your onset date. So in this situation, you may have had some unsuccessful work attempts. Ask them to consider that to be a part of your trial work period and an unsuccessful work attempt. And of course, some months may not even rise to the level of trial work period, which case, you're okay. But I would probably have a spreadsheet showing your gross earnings month by month. And correctly, as you point out, if you have expenses that reduce your monthly income, that comes off the top. So if you have business expenses, let's say you're driving Uber and you have gasoline, car maintenance, tires, things like that, that comes off the top. So you might be able to reduce your actual your income based on those expenses. but I think you need to look at it on a month-by-month basis, not as a yearly thing. 15,000 a year, 20,000 a year, and realize that 15,000 a year on its face is below SGA. So, my guess would be this is a situation where you'd argue unsuccessful work attempt and trial work period for those months that you were over SGA or over trial work period. Christina is here, as she is. I think you missed one or two live streams, but good to see you, Christina. I hope, and obviously, I know for a while we were worried about the fires near where you were, but I guess that's not been in the news. So I'm guessing that the rain has taken care of that, which is good. Ms. Crystal, how long does it take to receive back pay? Generally, if you're approved, you should see back pay in a matter of weeks, 2 weeks, week and a half. I do see situations where back pay is held up. The two most common scenarios would be one, if you applied for SSI, even if you're not eligible for it, SSI has to go through something called an income and resource interview, where they look to see if you have income and resources that would make you not eligible for SSI, even if SSI is never going to happen because of that reason, or because you're getting disability for every month you'd otherwise get for SSI, so it's offset. They still have to go through the exercise. That can take, 5-6 months. It can be a delay. The second time I've seen it delayed would be if the judge indicated or Social Security decided you needed a representative payee and you can't find somebody to do that for you. I have one case right now that I won, probably 6-8 months ago. The judge says, I want a representative payee. My client does not want to do that. They're in an impasse and nobody's gotten paid. And I've explained to him, you got to get a rep payee. He didn't want to do it. So money's being held up for everybody, which doesn't make a lot of sense, but that is what we're doing. Hannah, maybe. Sean asks, read a letter from Wisconsin governor talking about cuts to SSDI. Is this jobs or benefits? It's jobs. I think they're talking more about the jobs than anything else, not benefits. Okay. Typo, thank you. I don't see the typo, but okay. I hope there was no typo. Free case evaluation, I think I've got that on the crawl. Did I say interruption? No, not interruption. I think that well, here's what I'm hearing. Governor O'Malley, the former commissioner, said he thinks it's a very real possibility that benefits are going to be interrupted. I'm telling you, in my opinion, that's very unlikely because the political price that our elected representatives would face, that are still eligible for re-election would be too great. And the AARP in particular has such a strong lobby, they would really punish any legislator who did not stand on his or her head to stop that. So I just don't think that's going to happen. But I think as far as the cuts, they're talking about cutting, I think there's 50,000 employees at Social Security, which is like a 25-year low. They want to cut another 7,000 out of it, or it's 57. They want to make it 50. Bottom line is they want to cut, not quite, it's probably more than 10% of the workforce. And that could be a big issue for service. But I think that that's coming. I don't think there's any question about that. Interruption of benefits, that's kind of that's more of a concern. I don't think it'll happen, but we don't know. I don't think it will happen. I just think that politically, there's too many people that have too much to lose to let that happen. And the AARP would go absolutely bonkers if it did, and for good reason. Okay. You apply online for your applicants when they hire me. Some do. I'd say 35% of my cases are people hiring me to file the application. And they do that for a couple of reasons. One is because it's a pain in the rear end to fill out these 60 questions, especially on a phone. Second thing is I will put in there arguments, like the grid rules or a listing or something like that to encourage a faster approval. It doesn't always work, but I put it in there. Third reason is that when I get involved early, I get electronic access to the folder so I can see what's going on. And a fourth reason, which sounds kind of silly, but Social Security mails stuff out and stuff gets lost in the mail. And if it's going out to my client and to me, doubles the chance of things not getting lost in the mail. So that's why people do hire me early. Not everybody does, but many do. but it's all done electronically. I have filed probably 5 or 6 applications the last week, so it's still going. It's still working. Filing an application by phone, it means that you've got to talk to a person. And they've got to schedule an interview. What does that tell you? Those are the people that are, they don't have enough people. So I think that the utility, the wisdom of using a telephone application or trying to do it in person, I think it's really less and less desirable because there's not enough people to handle it. I'm not sure what the Department of Transformation is. Never heard of that term, but I think that certainly as part of the initiative to use AI and to use computers to expedite the process, filing an application online makes the most sense. It always has for a long time, but now especially it does. And like I said, I've got a person in my office. That's all she does is files application, drafts appeals, fills out forms and things like that. So, this is what we do on a day-to-day basis. And the other thing I try to do when I'm in an application is focus on the vocational issues. I think sometimes when I look at applications that were filled out by my client, and this is not a knock on the client, they're focusing on the medical issue. I'm focusing on, they've got a herniated disc. They have a herniated disc, and because of this, they cannot stand for more than 30 to 40 minutes. They cannot sit for 15 to 20 minutes. They have to lie down twice a day for 30 to 45 minutes. That's the part you got to really focus on because that's what's relevant in a Social Security case. Sarah D says, if I go to a hearing, there are mistakes found in the medical record, would that fall on me? Not sure what you mean by mistakes in the medical record. I think that if the doctor made an error in transcription, if there was something, let's say that, and I've seen this happen, the doctor will say, Sarah is a 35-year-old male with prostate issues, and Sarah, in fact, is a 43-year-old female with herniated disc. There are some situations where a record will contain incorrect information. What I do in my preparation is I will identify those records and I'll say, Your Honor, I'm looking at exhibit. I'll do this in a brief or in person in the hearing, but usually by brief. Exhibit 3F refers to an individual with a similar name, but it's not the claimant. It's a different date of birth. It's a different sex. It's a different medical issue. So please do not consider Exhibit 3F, page 43 to 95. And judges appreciate that, and they won't do that. So if you're not going with an attorney, then you want to identify the records that are like that are clearly erroneous because it's the wrong person. Now, if the doctor, basically says, Sarah, there is concern that Sarah is, drinking alcohol, a fifth of Jack Daniels every week, and you don't drink at all, that's more of an issue that you'd want to address with the doctor. You can I will tell you, if you get in front of the judge and say, Judge, I don't drink, I don't know what this is about, judge is going to look and say, well, the medical record says you do, I'm going with the medical record. So I think that I would certainly look at your medical records to see if there's any mistakes and try to get them changed by the doctor. If you can't do that, you can certainly fill out a form, notice, there's a form called Statement of Claimant or Other Person, and you could fill out, you can say, I'm reviewing the doctor's notes, and the doctor indicates that there is X, or that I am using marijuana, or that I'm doing, and that is absolutely not true. That would probably be a stronger denial than just denying it at a hearing. And certainly I would, write the doctor and say, Dr. So-and-so, I see in the record where you reference this issue. This is incorrect, or you call my knee problem a contusion when in fact it is going to require surgery. Please make that correction. So I think you can do things to make the record stronger. But yeah, in that sense, it is up to you or your attorney. But I like to do those things in writing well ahead of time. And if I can get them corrected by the doctor, that's what I would do. Just in case. Is that really your name, just in case? Maybe, but I'm thinking just in case is maybe a pen name. Can apartment managers evict people from their homes if their SSDI is put on hold? Depending on where you live, probably. And every state's going to be different. This is a matter of state law, but in many states, you cannot defend an eviction by saying it wasn't my fault. I mean, same reason where you can't say, well, I lost my job, therefore I couldn't be evicted. Yes, it is more sympathetic to say I lost my Social Security. And again, we're not there yet. So I know you're rightly concerned about interruption of benefits, but we're not there yet. And I don't think it's going to happen. But, depending on the state, now there's some states that may have different laws. I can only speak to Georgia. And Georgia, which is where I live, although I practice nationally, as you all know, I handle cases all over the country. But if you were an apartment dweller in Georgia and you missed a payment or multiple payments and you were being evicted and you try to defend that by saying, well, I'm on Social Security and, I shouldn't be evicted, that's not going to fly. I will tell you, and again, I'll just tell you what happens in Georgia. There is a requirement, I believe, in Georgia, in many counties, not all, that before you can be evicted, that you have to go to some sort of a mediation with the landlord, and there'll be a mediator there. And that may be a situation where you can, work out a deal where you let the apartment owner or the landlord know that the reason why you didn't pay was not your fault, and the mediator may support you on that. And that may help a little bit too. But again, we're not there yet. We're not. There has been, and I promise you, if I hear that there is going to be an interruption or I see it, I'll do a emergency live stream on it. But that has not happened. I do not think it will happen myself. Cindy G, thumbs up. Thank you, Cindy G. And Cindy, since we're talking about thumbs up, let me ask you if you could, or not just you, but anybody, and I've had people do this, leave me a review. Google reviews are great. Avo reviews are fine as well. But the reviews really help me because people go to the reviews. They go to Google and they do a search on Ginsberg Law Offices or Jonathan Ginsberg, and they see, for the most part, nice things. I mean, really, with very few exceptions, nice things written about me and about, the live stream and things like that, which I'm grateful for. My wife gets really good reviews as well. And, not everybody's going to be happy. I've had people give me bad reviews because I didn't take their case. And one person gave me a 1-star review and said that I won her case and it was great. I think she thought that 1 star was good and 5 was bad. But anyway, but for the most part, my reviews are really, really strong. So yeah, it really helps me if people do leave a 5-star review. That's very, very helpful, and I really would appreciate it. John Lee, hello, John Lee. How are you doing? Did you have another question? I don't see anything else from you here, but good to see you, John. Mr. Big Production, diagnosed with MS. And I'll tell you, MS is one of those things where multiple sclerosis, where, as I've always said, diagnosis does not win you a disability case. But an MS diagnosis basically says you've got a chronic medical problem that will gradually get worse. And the way MS works most of the time, and there's different forms of MS, that you'll kind of plateau at a certain level of functioning. Then you may have an exacerbation and it gets worse, and then you plateau there. Then you have an exacerbation and it gets worse and you plateau there. I think, when a judge is looking at it, they're going to look at where you are in the process, or when did the plateau get to the point where it was disabling. They'll also consider the mental health aspects of knowing you have a chronic debilitating condition and what that means in terms of your mental state. And then they'll look at the frequency of the changes in your condition, medication side effects. But because it's a condition that doesn't resolve, doesn't get better on its own, you may get more to the benefit of the doubt. So if you're at a level where, let's say that you have a difficult time walking, you can still sit, but you get fatigued, but you're not fatigued enough where you're falling asleep 4 times a day, you can testify that you get fatigued to the point where you may take a 30-minute nap every day. That and that's probably enough. So I just think you're getting more of the benefit of the doubt in a situation like MS diagnosis, as opposed to somebody with, let's say, a back problem, a herniated disc or something, where there could be a surgery that could resolve it, or it could be, the disc gets absorbed back in and you just naturally get better. You won't get the benefit of the doubt for something like that. Okay, John Renk. Is a supplementary hearing good or bad? I've also had a birthday since my last hearing, seeing an epileptologist, which I'm guessing you have epilepsy. on a regular basis. Supplemental, it really depends. I mean, I had a case this week where the judge, after the hearing, sent the record to a medical doctor for what are called post-hearing interrogators. I'm seeing more of these than I have in a long time, and these are basically they send the record and questions of a doctor. What do you think? And this doctor comes back and says, my client can do all these things, but there was no support for it. So I had to write a response to it. So I wrote kind of a scathing objection to it, basically saying that this doctor has never seen my client, did not discuss any records. We don't know what he looked at. We don't know anything about how he arrived at his conclusion. And the only thing he referenced was a report, one line in a report that's talked about significant problems. So, I asked for a supplemental hearing in that situation for an opportunity to cross-examine that medical expert. Sometimes judges do supplemental hearings because the person has about to go through a surgery. They want to know, did the surgery help? Or there were missing records, and they really managed to see that. The fact you've had a birthday, maybe that, again, if it's 49 to 50 or 54 to 55, that may line you up for a grid rule approval. Of course, that would eliminate past due benefits. So it's not a good or bad thing. It's just the judge obviously has something on his or her mind that they want to deal with. Nikki's World did my psychological evaluation less than 2 hours. Had doing math and blocks and went blank. Seriously couldn't do it. I think that what I find when I'm looking at psychological consultative reports is, the doctor will talk about what happened. Sometimes when you blank and you can't do it, the doctor can get the wrong idea and think that you were not giving your best efforts, and that can end up in the report. I would tell you, get a copy of that report. If you've got an attorney, it can be downloaded immediately, really within a couple of days. And if you see that there's some discussion that you didn't give your best effort, I would post a written response to that and say, this is what happened. I just drew a blank. It was very stressful for me. I simply could not remember some of the issues or some of the answers to these questions or how to do these things. I disagree with the conclusion that this was not my best effort, but I would get a copy of that report if you can. I think that will definitely help you know what to do. And again, if you've got an attorney, have your attorney discuss it with you. Corlil Katana has been here before. Greetings. How are you doing? Jeanette says, I'm not sure if you have a lawyer or not. Okay. Well, I think obviously one thing you could do is if there's anybody you think is your lawyer, call that person's office and say, have I retained you? They should be able to tell you. Or you could call Social Security, good luck getting through, and say, do you show that I have an attorney on file? But other than that, there's nothing else I can tell you that I don't know. Or you could, I guess, reach out to your elected representative and say, I'm not sure if I signed the paperwork. I can't get through to Social Security. Can you find out if I have an attorney? And they'll make one phone call and they'll get through. They probably have a special number, in which case you can find out whether you have an attorney. But the fact that you don't know says your attorney's not been in touch, which is not a good sign. Esoteric Fitness, I know you've been here before. TBI, I remember talking about that. Listening, glad to see you. Thank you for tuning in. This is our MS person, Mr. Big Production, diagnosed in 2020 with major loss of memory. It says it's maybe 14. I'm not seeing the rest of that. Okay. Went to the neurologist, I'm not sure what the rest of that is, but diagnosed in 2020. So now you've had it for 5 years. And, you're going to see some progression. So I think that, would tell me your case is going to be a little stronger in that situation. And you said something else down here. Just got denied at Recon in my initial app. No, you get denied that doesn't make any sense. You get denied at initial, you file for Recon, then if you got denied at Recon, they added some random child's information in my case and said a pediatric doctor was what they used to deny, have current medical records. Yeah, that would be certainly, if you are at initial and you file for recon, that would be something I would put in the recon that, the denial was based on records that are not me. If you're requesting a hearing, that would be something that would be part of my brief, or certainly a letter to the adjudicator saying that this, should not have been part of the record because it's not me and it's a random child and I'm not a random child. Yolanda Jones. Hello, Yolanda. Hope you're doing well. She's 53 to 9 first claim. Recon, how long will it take with everything going on with the state? It depends on what state. But recon, I'm telling people 8 to 12 months typically. All right, Jeanette, I'm not sure. I'm sure if I had a lawyer, they said they would try. So I'm not sure. Again, as I said, you need to call Social Security or try to call the person and see, did I sign a fee agreement? Did I sign a form 1696? That's what you want to find out. 1696 is a representative form. The fee agreement obviously would say you've retained somebody, but the 1696 is what you're really looking for. And that is a form. Let me see if I can pull one up for you so you can see it. Let's see if this looks familiar to you at all. That's the fee agreement, 1696. It's a 6-page form now. So let me share my screen so you can see that. Well, let's see here. Presents. Share screen. 1696. There we go. Okay. So here's the 1696, if that looks familiar to you. And the first part is just some discussion. This is the main part, the claimant's appointment of representative. And, you'll see something that looks like this. Have you seen something that looks like this? And you can just type in form 1696 and look at it and see if that looks familiar to you at all. But that would be where you've appointed somebody to represent you in your Social Security disability case. Christina says, do not forget to like, share, comment, and subscribe. I would agree with all of those. Subscribe and hit the little button so that I think it's a little bell, so that you'll get on notifications and when I go live as well. Okay. Video commentary. Okay, so No Sky. This is somebody who commented on one of my videos. With the SSA hack and slash and wait times expected to increase, would be wise to apply now versus waiting for the cut to take effect? Yes, I would say that it's not going to get better. So if you're on the fence, apply now, because the sooner you get your case in process, the sooner it's going to get decided. And the sooner you may get the case moved along to a different stage before things start to slow down, do that. I would absolutely agree with that. I think it's, time is not on your side. There's no reason to wait, because I think that, Social Security is under a lot of uncertainty now, and that's only going to increase in the future. If it takes 2 years to go to a judge, asks SA, but not because of an appeal or denial, does the applicant have to get a new MRI for the back? Again, I think that when you're going in front of a judge, they want to see current information, current records. And so if you go to a hearing and the last MRI, a back pain case, is 2.5 years ago, the logical question is, what is going on now? And of course, if you have a surgical situation, you're going to need a new MRI. My rule of thumb is you want to have an MRI or CT or objective test within about 2 years of the time you're going to a hearing. I think if it's longer than that, it starts to become stale. But I realize these things cost money. Obviously, MRIs nowadays you can get them for $400 or $500 at standalone MRI clinics. So if that's at all possible, that will benefit your case. Okay, Christina makes a good point. If you're going to leave a review, make a comment. Don't just say 5 stars. Well, I like that. That's great. But if it says 5 stars and the live streams really helped me, or the videos helped me, or Jonathan answered an email for me, or I won my case, that really is what does help me. And I really appreciate it. And again, that's not why I'm doing this, but I appreciate it when people are nice enough to leave a review, because it does help me grow my practice. And yeah, that's I'm trying to keep my staff really busy, and I'm trying to handle as many cases as I can. So the more people hear about me, the better. Okay, chords of gratitude. I have degenerative disc disease, bulging lumbar discs, bone density loss, osteoarthritis, osteoporosis, pituitary tumor that was treated, now empty cellular trasuka, early menopause, um, adenomyosis. Let's see if there's anything else here. Migraines, vision loss, hearing loss, undiagnosed reason for POTS, which is where blood doesn't go to your head and you tend to fall out when you stand up too quickly. When I qualify for SSDI, 58, disabled female veteran. The 58 makes it strong. I think you've got, it looks like some conditions with objective medical evidence, where the objective medical evidence would document it, like the degenerative disc disease, like the pituitary tumor. Um, you know, some of these things, are they going to cause you to not be able to work? Bone density loss, osteoarthritis, everybody has that. Osteoporosis, the pituitary tumor. The question is, are replacement hormones, you know, keeping your hormone levels up? Early menopause, again, how is that disabling? So I think that those are the real questions. The migraines, the vision loss, migraines, it's going to be based on what you report. The vision loss can be objectively determinable. Hearing loss can be measured. Idiopathic POTS, again, can be evaluated by a doctor. So you have a number of things there that are not easily imaged, that they're going to rely on what you tell your doctor, what your doctor puts in his record. It does help that you're 58, because really what you're going to have to do is prove you cannot do light work. And, for example, if you've got a doctor who says because of POTS, that, you cannot be on your feet more than 2 hours a day, or you need, an assistive device like a cane or a walker nearby, that may be enough to get you into light work, or that you cannot lift 50 pounds, which is medium work, the next level up. So, there's very likely, and you've got the back issues and the osteoporosis, I think you can make a pretty compelling argument that light work would be, a problem. So your RFC, your residual functional capacity, is going to be in a reduced range of light work, probably. And assuming you've got other conditions that make transferability of skills difficult, that says to me you probably meet the grids at 202.06. So I think all in all, based on what you're telling me, I think that says to me you've probably got a pretty good case. Okay, let's see here. Just in case, that to MKE, and I don't remember what that was about. Let's see, Yolanda, somebody's responding to Yolanda. I'm 53 as well. Rejected, then got a rep, not a lawyer, appealed, and things went even further to approval. Okay, so again, I think that, having a representative statistically makes your chances of winning much greater, just because, certainly in a hearing, the hearings last 45 minutes, and you don't need a judge to spend most of the time in the hearing explaining to you the issues. It gets them frustrated because it throws them behind. And it's much better if you have someone who can kind of zip through that part of it, plus knowing how to make a critical argument, knowing how to make a listing argument, knowing what functional capacity is. So, yeah, I think certainly going to a hearing, you do not want to do so without an attorney, in my opinion. There are non-attorney reps out there. Some are good, some are not so good. That's your choice. I mean, I think that having an attorney makes the most sense, but of course I'm an attorney, so it's a little self-serving, but that's my take. Okay. Michael Grants. I was suddenly taken off SSD. I had no grace period, just taken off this month. What can I do? I've been on disability since 2011. Worked part-time. I knew my benefit was in jeopardy. You should have gotten some notice, a notice to terminate. I mean, I cannot believe I know for a fact they don't just terminate you. They send you a notice, and you have a right to appeal. So if you didn't get that, that's a different problem. But, the assumption is going to be And if you, let's say that you filed an appeal, and now, which you could certainly do, and say I never got notice, they're going to come up with a letter that says it was sent out to you. How do you prove you didn't get a letter? Proving a negative, you can't. So, this is a real problem in that regard. It might be worthwhile to reach out to your representative, your elected representative. Although, again, my experience is when people go to Social Security and say, I never got that, Social Security says, we sent it, and judges are going to say, we believe Social Security. So, I think that I would certainly, this may be a situation, where you, I don't know, I mean, really, you need to find out. I would certainly call Social Security and find out, did they send you a letter? So what does it say? What's the grounds for it? And then, file an appeal. It's called a request for reconsideration. I think it's the 501, but just look up request for reconsideration after termination, and get that filed ASAP. And then, try to get your case in front of a judge as soon as you possibly can. You could talk to attorneys, again, finding somebody who'll take it. If there's been work activity, that could be more problematic. So here's what I would do. I would tell you to do this. First, I would call Social Security, reach out to them, maybe have your elected representative reach out to them and get copies of all the paperwork, or make an appointment if you can. Go see what's in the file to see what they actually sent you or claim they sent you. Number two, you need to make a list and a spreadsheet of all the earnings, the gross earnings you've had since the date of your since certainly the last 5 years. I know it may be hard to do, but you're going to need to do it. And then you look at that to see whether you were over SGA. If you were over substantial gainful activity for those years, you were working and collecting benefits, you're now in overpay status. That is a problem. Now you can move to have that waived. That's a problem as well. You got a mess here. And this is an example of where Social Security doesn't give you real-time information about where you are with regard to trial work period or earnings after onset. And, you end up with this situation where they terminate you, and they're probably going to come after you for an overpayment, and you didn't even know there was a problem. This is part of the inefficiency of Social Security that, quite frankly, is what, some of the folks are talking about who support, Mr. Musk and Doge and all that this is incredible inefficiency. This is an example of it. It doesn't help you, but I think right now you're in the information gathering mode. You got to find out everything you can about your case, is what I would tell you, and what really happened. Sean Hanna, was O'Malley let go? Was the contract up? The statements got everyone scared. He resigned. After Trump won, he resigned, I think, before the end of the year, and he ran for the head of the DNC, the Democratic National Committee. He did not win, but that was what he was. He resigned. I guess he felt that the handwriting was on the wall, that he wasn't going to be able to do very much. He was a really good commissioner, and I think he really supported people who were applying for disability. He was certainly very friendly and supportive of the attorneys that do this work. So I was sorry to see him go, but he was not going to be kept on. And so I guess he felt like, let me try to run for the head of the DNC, and maybe that'll, help me. I don't know what he's doing now, but he'll probably run for president. He was a good man. I think he really, had his heart in the right place. And, I don't know what he's going to do with his life, but he certainly did good things for Social Security, and I have a warm spot in my heart for him. Okay, so Mr. Big Productions got MS, done studies at National Institute of Health, and treated by National Institute of Health doctors, with all the information for. Yeah, that is going to be very credible medical evidence, because, it's like the Mayo Clinic. So that's really helpful. And hopefully those records will help your application for disability. Okay, this is Pricey Joy is talking about Nikki, who had the problem at the consultative psych evaluation. Also said, I didn't, you got these blocks, you got all these tests. It can be, I'm sure, very nerve-wracking, especially if you're nervous and you've got underlying mental health issues. It can be a real problem. So that is something that does happen, and hopefully the doctor at the consultative will recognize that your issues were not, you're not making anything up, that you basically are legitimately struggling. Okay. with mental health issues that would preclude competitive work. DC Randall, thank you. Well, I appreciate Randall. I appreciate you coming on and along with everybody else taking your time. I realize these live streams go on for a couple hours and everybody's going to watch for 2 hours, but thanks for your time. Got a letter saying SSI needs more information about my condition. Now you say SSI, you mean SSA, Social Security, not SSI. That's a type of disability for people who don't have enough earnings credits for SSDI. I know people call it SSI if they call, tissues, they call them Kleenexes or copy machines, Xerox machines, but SSI is something very specific. So you want to be, and I would just say this in general, when you're dealing with Social Security, be specific with your terms. So when you talk about Social Security, it's not SSI, it's Social Security, SSA, Social Security Administration. If you're talking about, I can't walk, very long, is that 10 minutes? Is it 30 minutes? You want to be specific. So this is a good place to practice. I'm not saying that to criticize you. I'm just saying, when you're dealing with them, they don't know what you meant. I kind of do, but you want to make sure you give them accurate information when you ask questions of Social Security, certainly. Got a letter saying they need more from my condition, range of motion, mental testing. What does that entail? It probably means they're going to send you out for consultative evaluations. And if you don't know what that means is Social Security has the obligation, to develop the record in a disability applicant's case. And part of that is to send you out to consultative evaluations, where they will send it to a doctor and their panel to evaluate your physical condition as well as your mental health condition, or both. Could be either or both. I will tell you, I've seen recently more cases than I've recalled seeing before. They didn't send them out. Maybe a money saving thing because they're having to pay these people, per exam. So, whatever it's worth, I'm seeing fewer of them than I used to. But when they send you out, my experience has been that the physical consultative evaluations are less valuable. A lot of times it's to doctors. That's all they do. They mostly get their money from helping insurance companies deny claims. So those aren't usually that helpful. I would also tell you that I had Dr. John Foster on a couple months ago. He's a consultative doctor, does physical exams, and give a listen to what he had to say. And he does it, I think, a little differently than many others do. So, you may get a good consultative doctor, which I think he is. The mental health CE is going to go to a psychologist, typically a practicing psychologist. And those, in my experience, like we had a couple of people talking about, the 2-hour exam, they tend to be a little more thorough. These are doctors who, are real doctors. They deal with real patients. They're not just working, they're not insurance company hacks. They're real doctors. So my experience as a rule, not every single case meets this, but as a rule, the physical consultative evaluations aren't going to be all that useful or helpful. The mental health ones, you more likely than not will be helpful. So what they're saying, Randall, is that they're going to send you out to develop the record further. Obviously, if you have your own doctor's physical or mental health, those records should be more persuasive than a one-time consultative, but they're going to send you out to develop the record a little bit, and hopefully it will at least eliminate some categories of jobs. Hello, Tara, and thank you for asking people to like and subscribe. I really appreciate that. Tommy Scruggs, 56, started drawing in June of 23. Will you get a review? I don't think so. I mean, you're 56, which means you're getting close to retirement age. Now, all this hinges on no changes in, up until this point at least, a 56-year-old is probably not going to be a person they're looking to review. They're looking to review the 35-year-olds who are going to be claiming Social Security for the next 30 years. 56-year-old, you've got less than 10 years to full retirement. You're not, and plus being older, it's more likely that your condition is going to be permanent, not likely to recover from it. Could that change? Yes, it could change. But right now, I would tell you, the main thing you can do is go to the doctor, follow all prescribed treatment, keep records. If you try to work, keep records of the hours you worked. But I think that the odds that you'll be reviewed are small, and even smaller that if you are reviewed, that you'll be cut off. Julia Jones says, exactly. I'm not sure what you're saying exactly about, but exactly. Okay. Social Security just, okay, get a free, this is the case evaluation. I got that on the crawl here as well. Jenny Joe. Hello, Jenny Joe. Good to see you here again. Hope you're doing well. Um, Sean says, I called local office in Wisconsin on hold 45 minutes while other folks working from home get back to the office. Prayers to those pending apps. Now, Social Security, they have been told, other than at the hearing level, to go back to the office. And many people think that we'll see a burst of productivity because they're back at the office. Now, the question is, are there enough spaces in the office? I was talking to a judge I'm friendly with, and he was telling me that, there's not enough space for some of the non, judge personnel to come back to because they've cut space during COVID. Now, where are they going to put them? So I don't know. I saw today where Social Security had put up that they're going to sell a bunch of buildings rather. Where are they going to put these people? So, these are some of the practical issues. Yeah, it's easy to say, come back to work. When you get there, there's no place for you to sit. What are you going to do? So I don't know. Okay, Julia says, we need to discuss me not going to the doctors soon. I'm a client. Okay, and again, we can talk about why you cannot go to the doctor. Okay, Price Joy, I will. I don't think I can add much to that. And if you're just listening to this, there is a poop emoji, and she wrote, "Poop emoji, meet fan." Okay, love it. Okay, Mr. Big Productions got MS, 40 years old, diagnosed in 20. Said onset 13 years ago, advanced. How do I handle that? Yeah, you're young. I have one cases for people in their 40s with MS because it is a progressive disease. I think you're going to really need to have firm support from your doctors, your neurologist about your loss of functional capacity. Because at 40, you're not going to get much of the benefit of the doubt. That's the difference. You're going to have to really show it in the record that your condition, your MS, is significantly advanced to the point where you simply would not be reliable in any kind of job. But you're going to need a functional capacity evaluation from a treating doctor, and even then, it's going to be more of an uphill battle because of your age. Okay. You apply. Okay, I agree. So this is the question. Should you apply sooner rather than later? Yes, apply sooner rather than later. I would agree. John Lee, you said hello before you didn't have anything else. So now you got a question, which is good. Filed for SSDI in November of 23, 60 years old, multi-level disc disease, severe spinal canal neuroformental stenosis, multi-levels of my cervical spine. Had a fusion surgery at C6-7, scheduled for second surgery with the spine, getting steroid injections every 3 months. Also taking antipsychotic medications, antidepressants. Don't take hard narcotic pain medication, and too many bad side effects. And filled out a work history report, adult function report, attended CE exam, both physical and mental, this past November. Okay, it has been very difficult for me to do a lot of activities in sleep. So declined with my chance of approval in your initial claim. Who does residual functional capacity work report? 14 months waiting so far. Okay, I think you've got a good case. You've got a lot of, all the things you're talking about are objective evidence. You're, of an age where it's going to be a lot easier to win. You've had surgery. You've got another surgery planned. You've had epidurals. You've got a good case. Again, they make it really hard to meet the listing, but I think you meet the grid rule. Certainly look at grid rule 202.02. There's also something called the PALMS regulation, which basically says at age 60, they would have to prove that you could go, you have to make minimal vocational adjustment to any job that you might take, which means essentially you have to go back to your past work. Which again tightens it even further. So you've got a winning case. Will it win at initial if you get the right adjudicator looking at it, and the adjudicator understands the process? It should, but I just don't know that I can't give you a guarantee on that. There's just no way to know. But yeah, I think that you have a winning case. You do have a winning case. Julia says a lot of people die waiting. 30 something thousand a year die waiting. That's exactly right. Um, do I see more approvals for mental or physical? More approval for physical, no question. Physical impairments can be imaged. Mental impairments cannot be. Social Security likes images. They like things like MRIs and CTs. And Kelly Brickner says that working remotely can be more cost effective. I agree. I mean, look, I work remotely. I have an office. My wife and I, have an office. It's got my name on the door. I go in once a week. I work at home. This is my home office. To me, it's a lot quieter here. I've got everything I need: my computer, my scanner copier, my phone, office phone. It's all voice over IP. My staff is all remote. Jen, my paralegal, is in Nebraska. I'm in Atlanta. I've got somebody in Mexico City, somebody in Guatemala. I've got somebody in Oklahoma, 2 people in Nebraska, somebody in Florida. I'm a big believer in working remote, and it doesn't bother me to work by myself. I find it refreshing. It's just much quieter here. I get stuff done. I've got my weight bench out there, so when I want to take a break, I go lift some weights. I'm able to discipline myself where I can work. So I love working remotely, and I think Social Security people do as well, because they can be at home. Now, are there people who abuse it? Sure. I mean, I've called Social Security, in the past, and I'll get on the phone, I'll hear a TV in the background, I'll hear a kid yelling, which says to me this person's watching TV or taking care of their kid while they're supposed to be working for Social Security. But we also avoid the traffic, and there's pros and there's cons. And I think there are ways. I know that some employers will have devices on computers where they can see if you're there. They can see with the keystrokes, they can tell, and you get in trouble if you're not. So it's going to depend on the person. But for me personally, I love working remotely. I think it's great. And nice thing is, I've been able to take vacations at times. I've done hearings from Florida, from South Carolina. It doesn't really matter. I did a hearing from Toronto one time. So you can do hearings from any place, and it's all electronic now. So it's great, in my opinion. Bonita Wilson says, "What happens if your doctor will not do the CDR paperwork?" And what he's getting at is the CDR paperwork is the forms that Social Security might ask a doctor about your current condition and your capacity for work. And some doctors don't fill out forms. So sometimes you got to offer them money to do it, and they may do it then. That's a problem because, like I said, my case today, the judge is like, "Where's your form?" And of course, in this situation, I will tell you, my client had met the surgeon one time, and the surgeon had looked at the radiology reports, and it's like, he needs surgery. He wasn't going to do a functional assessment. It just wasn't going to happen. So I hate to say, you must need to get another doctor. I mean, you got to find somebody who'll do a form, an assessment, because you're probably going to need that. And this is again an area where it puts the burden unfairly on a claimant to fill out a form, or to get a doctor to fill out a form. What if the doctor won't do it? You're going to have to change doctors, deal with all the insurance nonsense. It just doesn't make sense to me, but that's what they seem to require sometimes. All right. Christina says, "Thumbs up on the video." Yes, thank you very much. Appreciate it. And Pricey Joyce says, "Not about your list of conditions, about how they affect your ability to work. Don't mean to be a smartass. I was approved. Probably remember this well." You're absolutely right. And I say this over and over and over. And I will tell you, the number one thing that people get confused about with disability, and I'll readily admit, when I first started doing this 30 years ago, I was confused about it. You hear about Social Security disability, and the definition of disability. Do you have a medically determinable impairment that prevents you from engaging in substantial gainful activity that has lasted or expected to last 12 consecutive months or result in death? First thing you see is medically determinable impairment. So what do you think? This is about your medical problems. Well, it is only to the extent that your medical problems are going to affect you working. And just how I answered the person, the 58-year-old woman with the long list of conditions, some of those conditions may not affect her working, and they may not be disabling, and I wouldn't focus on those. Example, let's say you have an unsightly scar on your hand, on your left hand. Doesn't affect the function of your left hand, but it does affect it's ugly. You don't like the way it looks. Okay, now you could certainly make an argument that there is a mental health component there. Having the scar might cause you some distress, but is that enough to prevent you from working? Probably not. It would eliminate jobs where you're a hand model, but that's one job. But any other job, if you have a bad scar on your wrist, is not going to stop you from doing that. And that may be something that you look at all the time. It reminds you bad memories of a bad accident or something like that, but it is not disabling. Again, she mentioned, the woman mentioned, that it was nice enough to pose a question, osteoporosis. Well, that is loss of bone density. That will certainly eliminate jobs around hazardous equipment, maybe, ladders, ropes, and scaffolds, dangerous situations. But, most sit-down jobs, unless there is a fracture, it's not going to be disabling. Now, again, it might be enough to eliminate medium jobs, which again, at 58, in her case, she could win if she's able to do light work. Or another way to put it would be, she would have to be able to do medium work not to be disabled. Medium work involves lifting 50 pounds. Would a woman with degenerative disc disease and osteoporosis, would that person be expected to lift 50 pounds? No. So in that situation, it would be relevant. But, if you are 35 years old and you have osteoporosis, probably not disabling condition. A scar, not going to be a disabling condition. So you really need to look at all of your conditions through the lens of, does this prevent me from being reliable at a job? That is the only question. Does this prevent me from being reliable? And in fact, I've had people say to me, hey, Jonathan, I got 15 things going on, 15 medical conditions. And I'm going to say, okay, write them all down, then rearrange them, put them on index cards and rearrange them. Which ones cause the most functional limitations and which ones are objectively determinable? So an objectively, let's say a back injury with an MRI, that's going to be at a higher priority, in my opinion, than, maybe depression, where there's no objective test. And it still can be serious, but, is it moderate depression? Is it severe depression? Then you get things like scars or osteoporosis for a younger person. That's going to be at the bottom of the list. So, sometimes I'll tell people, you've got all these things, list the first 3 or 4, don't put 15 things on there. You can, but judges what they do. I will tell you what they do. They will look at that before hearing, and they will declare that these first 7 or 8 conditions are what they call non-severe, meaning there's not been much treatment for it or no treatment for it. And there's no evidence that causes any functional limitations. So they get rid of it at the non-severe level. And there's something called the 5-step sequential evaluation process, which is what the judges go through. Step 1, are you working? Step 2, do you have a severe impairment? And you get rid of it. Step 2, no severe impairment, it's gone. So, it may not be worth even including on the application. I think what also it does, it sends a message to Social Security that I hate to use the word hypochondriac, but it suggests that you are invested in being disabled. And, not every person, with 15 conditions they may really have it. They may have 15 conditions, but that's the risk you run. So you want to be strategic about identifying the conditions that are disabling and what you want to put on there. Again, my feeling is that, and I've done thousands of hearings, judges are going to base an approval on 1 or 2 things, not on 15 things, even if it's a combination of things. So I think you just got to be careful about that. But I think that Pricey Joys makes a very good point. This is about the functional limitations, but I would just urge you that when you're considering applying, think about those things that are most relevant to a functional, evaluation, a functional assessment of your ability to work. Okay. Debbie says, is there a way to get the SSA employees back fast enough to get the checks cut? Well, again, let me reiterate, there is nothing specific that I've heard that checks are not going to get cut. I think that, what Mr. O'Malley is concerned about is, a mass exodus of staff, and that, things start to go bad and there's nobody there to fix it, not enough people to do it. The checks, if you're already receiving a check, that's kind of automatic. those are not going to be the ones who are going to be affected. I think it's probably going to be the people that are in transition. They've been approved. They get waiting for that first check, or their check is somehow it was stopped now. It's being restarted. But I don't think we're going to see an interruption of benefits. I could be wrong. I don't think I am, but I don't think we're going to see it. But it has not happened yet. Martini shot. I've seen you here before. Good evening, Martini shot. How long after you appeal the first denial within 60 days do you hear if it's approved or denied? So what you're saying is, what is the time frame on reconsideration? Well, number one, you raise an interesting point. I don't think you meant to raise, but that is, if you get a denial, get your appeal filed quickly. You got 60 days. No reason to wait 60 days. Just get it filed. Okay, just file it as soon as you can. So once that appeal is filed, it's going to take probably 8 to 12 months, depending on where you live. You're in Texas or Florida, it's going to be longer. But 8 to 12 months for them to make a decision on recon. They will probably send you out for more consultative evaluations. They're going to request updated medical, have a medical consultant review it. If there are no new medical evidence, then it's probably going to be denied pretty quickly, relatively quickly. It's 5-6 months. There's nothing's changed. If there's something new, they got to get it. So, generally speaking, it's going to be, 6 to 12 months. Whether if there's nothing new, it's going to be denied. If there's something new, it's got to be significant enough new to move the meter that they would approve you. But I would tell you, in recon, assuming you're going to get denied, if you get approved, that's a bonus. It just doesn't happen that much. But 6 to 12 months, and if you have new stuff, it's going to be closer to 12, I think. Just a crazy Jen. Hope you're not. Cause I've got a paralegal named Jen, so I hope you're not just I hope my paralegal's not crazy. Just kidding there. Okay. Good evening in chat. I was just denied a hearing stage yesterday. I'm sorry to hear that. Haven't read specific reasons. Age is against me at 39. Correct. Judge at 38%. Very low. Silly for me to appeal, or to get the same judge assessment from the lawyer. Last insured date in 2021. Okay. So, Jen, the issue here is if you don't appeal, then you cannot pursue SSDI anymore. I would think that, all those factors you identify, your age, low percentage judge, date less insured's passed, it might be worth having somebody look at it, having an appellate lawyer look at it. But you're probably right. They're probably not going to take it. This may be a situation where you try to go back to work. I mean, I think that the odds are stacked against you. I would unfortunately have to tell you that. Odds are stacked against you. The chances of you winning with a judge at a low percentage rate with your age, just pretty low. So you're maybe best off is trying to go back to work, get more work credits, and if things continue to be tough when you're in your late 40s or maybe 50, reapply. At that point, you went back to work, you showed that you were fighting this. Now you've got the grid rules in your favor. You're over 50, you have that bias in your favor. So I would never tell somebody not to appeal without looking at their decision, but I think it's going to be an uphill battle. Okay, so Pricey Joy talks about, yeah, that's true. What are these years? I'm not sure which. Said 6 months. Not sure if I understand, Mr. Big. I'm not sure what you're asking. If you're not the 6-month waiting period or 5-month waiting period, if you don't know what that is, in a disability case, the first 5 full months, not partial months, but got to be full months. The first 5 months after you're found disabled, you don't get paid. Now, if you applied and your onset date's more than a year prior to your application, the 5 months can run before you'd be eligible to be paid, and then you won't lose any money. If your onset date's within a year of your application, then you won't get paid that first 5 full months. That may be what you're talking about. So some people say 6-month waiting period because unless your onset's the first of the month, if you're the second of the month on, it's going to be that partial month doesn't count. I'm not sure if that's what you're asking, but that's the way I'm reading it. So tell me if you're asking something different, but that's what I'm thinking there. Mr. Stiles. Okay, thank you. I much appreciate that. I'm glad it's always great to win. In fact, I use this little utility. There's a program I use that automatically pulls um, status of all my cases every day. And so when I look every morning, I'm like, do I get an approval there? Yeah, and I got one. I got one yesterday. I got an approval. I got a denial one on a judge who never approves anything. Didn't surprise me there. Um, but I got an approval, and I got another approval on one where the judge changed the onset date to basically 4 months before the hearing, so there's no past due benefits. So my client won, but there's no fee. I don't get paid, which kind of sucks, but happens sometimes. So, but we're going to look at it for appeal, but I'm thinking maybe not because it was based on an age change and the grid rules and all that stuff. And that happens sometimes. So I'll ask them for a nice review. We won, but win the battle, but there's no fee. But that happens sometimes. And the other one, like I said, just a crappy judge who denies everybody. It was a tough case, but another judge might have approved it. But then I've had 2 or 3 last week where I got approved on that should have been approved, and that's always a great sign. But yes, thanks, Mr. Stiles. I appreciate it. Betty, just checking your assistant, Darlene. Yes, I do. And I think I asked, I know you had sent me a case eval and I had Darlene contact you. That is correct. Darlene and Madeline are the two people that would be contacting you, and I can't. I had hearings yesterday and today. I have, and I usually will have some because we get a lot of leads, thank goodness. I have Darlene and Madeline do my initial screening. You had a good case, as I recall. The facts were pretty strong. So, but yes, Darlene's great. She's a really, really nice person. So you'll enjoy talking to her, and we'll eventually talk, obviously, if we decide to proceed. But yeah, Darlene works. It does a great job for me. Okay. Okay, so this is John Lee, sleeping requirement. Yeah, I think you got a good case. I do think you have a good case. Who does the residual functional capacity work report? Well, the RFC is a legal term, since residual functional capacity. A judge ultimately makes that decision. The form, or a functional capacity form, to be accurate, you would get that to your doctor. Your doctor would fill that out, and you would submit it as evidence that really translates your medical findings into specific work limitations. So having MS, for example, or in your case, a back problem, okay, what does that mean in terms of your ability to sit, stand, walk? You were limited to 10 minutes of standing before you have to take a 5 to 7 minute break. That is part of a functional capacity evaluation. Inability to use foot controls, that's part of it. Inability to climb ladders, ropes, and scaffolds, that's part of it. Need to take unscheduled breaks, 3 times during a course of a day for 10 minutes. That's part of it. So a functional capacity form is where the doctor identifies those functional issues that are directly arise from your medical problem. And it is a very, very powerful tool if you can get one. And I think I pointed out there are free ones out there on the internet. And let me get you a couple of, I'll put them in the group chat. Give me 1 second here where you can see them. Here is one. I used to have this. Here's one here. I'll just stick this one in the chat box window. This is where you get a free functional capacity form. And these are just forms that you can use. You can modify them if you wish, but they will help the judge understand the functional implications of your medical problems, which is really the issue in a disability case, the number one issue. Vince, you are late, but you are here. 52 degrees and rainy here. Let's see what it is here. It is in Atlanta. It is now, it says 39 degrees, feels like 25. There's a freeze warning tonight. So we are colder here in Atlanta than you are in Michigan. Can you believe that? Tomorrow, and I hope it is true, it is supposed to be a little windy, but tomorrow is going to be a high of 51. So I'm supposed to play tennis tomorrow. I will have to, and it's going to be windy, but sunny. So I will be wearing long johns because 51 and windy is going to be cold. I'm hoping we're getting close to the end of this ridiculous cold weather because I like the warm. I'm I'm from the South. I just don't like the cold. Okay. Coralil, I'm 7 years of portions of my initial VA claim. Yeah, the VA is difficult because it takes a long, long time. I don't do VA work, but I looked at it at one point, and that was the reason because it just took so long. All right, Jen. Jen is my paralegal in Nebraska. Jen, there was a woman here before, and her name was Just a Crazy Jen. I thought maybe for a second that was you, but it is not. So, unless you've got two YouTube accounts, but this is our not so crazy Jen in Nebraska who handles a lot of stuff. I'm glad she's there to handle all that stuff because I can't keep up with it. Jim hadn't had a CDR since December of 23, awarded continuing benefits, be 59, retired, see a doctor on a regular basis, expect another CDR. Probably not. I mean, 59, I think it's just not likely. You're not the people who they're going after. So I think, again, never say never, but I don't think so. Tara says, hello, Jen. Kathy L. I've not worked for 9 years, was denied twice in 2019 for degenerative disc disease, losing damage by knee, need partial knee replacement with cartilage. Can I reapply again? The problem is you're not going to probably be insured for disability because your insurance, you've got to have most of the time, unless you're younger, you've got to have 20 credits in the last 40 quarters, which is 5 out of 10 years. You haven't worked in 9 years, and so this is 25, so that would mean 2016. Your insured status probably ran out sometime in 2020. That means you've got to prove that your disability began or your condition was at a disabling level as of your date last insured, probably 2020 sometime. That's 5 years ago, approximately. That is a long, long time. So, and if you were denied, you didn't say if you went to a hearing or not. If you went to a hearing, then you got a bigger problem because you can't really go back before then. If you're denied administratively, I don't think it's much of a problem. But the recent damage to the knee isn't going to help you if your insured status ran out 5 years ago. So I think you need to, I would do this, get your My Social Security statement, look at your earnings record. And I wish they would tell you your date last insured, but they won't. But if you see a lot of zeros in the last, 6, 7 years, then probably not going to be real good as far as being insured. Tina needs help. Well, Tina, fill out a case evaluation, and I'll see what we can do. Tara Slaughter says, I'm 60 years old. I received my first CDR in 7 years, which, it's interesting. I'm seeing more people that are 60 that are getting them. So there's a random factor to it. So I used to always tell people, don't worry about it because it's probably not going to happen. Well, maybe we're seeing more of them. I still think it's not the market they're going after. It's a long form. They're the doctor with 3 months. So always send me a long. Why would they send me a long form? So she basically received a CDR. You go to the doctor, they got the long form. I think there may be either a couple of possibilities. One is the random factor. They just randomly send the long form to some people, and you happen to get it. It doesn't make sense to send a 60-year-old a long form CDR. It just makes no sense. You're not the people that are the ones they're trying to cut off, but you got one. So it could be random. You just happen to be unlucky to the short straw. Number two, it could be they see earnings and they want to know if you're working. They think you're working. Number three is there was something in the medical record that indicated you would be have improvement. There was a reference to a surgery that was going to happen, or that the doctor felt like with a certain amount of rest you would be okay. So that could be it. I mentioned this before, and I still can't find evidence of it, but I believe it does exist, that you are coded in your file someplace whether medical improvement is expected. And if you got coded that it is, coded CODED, that it is, then that may be what's going on here. Fill out the long form. It's just ask you questions about your work history, about what your doctor is telling you, and send it back in. And if really nothing has changed and the medical is still strong, they will not move to terminate. So all this means they're asking questions. But again, if you basically show nothing has changed, you're still disabled, then they'll send you a letter saying we've decided not to do anything. Kathy worked for 30 years. And this is a common question I get. you work for 30 years, but you haven't worked the last 9. The problem is you are not insured for disability anymore. You're insured for retirement, but Social Security disability looks at the last 10 years. Not really fair, but that's what they do. So, even though you've had a long work history, it's not recent enough, to give you a, certainly if your onset's going to be the last year or two, you're probably not insured. So I think that's going to be an issue. Hello, No Sky says hello, Jen, and hello, Christina. Jenny, does SSA consider virtual telehealth PT acceptable, or is mainly for HE health education? Good evening, Jen. I'll say good evening on behalf of Jen back to you, Jenny. Yeah, I mean, I think that, telehealth physical therapy, I mean, it sounds like it's educational. So, yeah, that can be certainly part of it. Like you said, educational. But normally, physical therapy is hands on. So, I don't know that I would be comfortable with 100% virtual physical therapy. Maybe there's some protocols out there where they walk you through using a webcam exercises. But I've gone to physical therapy. I went to physical therapy earlier this year because I was having some stiffness in my hamstrings, and the therapist did massages and gave me exercises, but was physically there. So yeah, for the education part, sure, but I wouldn't have exclusive telehealth for physical therapy because it's sort of physical. There's the physical part of it. It's physical therapy, but you got to have the physical. That's what they do. They deal with fit manipulation or positioning you or things like that. I know at one point I had a physical therapist. Back in the day, I was playing basketball. I would get my back would go out, and so I went to this gentleman named Herb, and he was amazing. I mean, literally, I would go in looking like a pretzel, and Herb would, in an hour, would have me walking straight. So yeah, great physical therapists can do wonders. In fact, Herb used to ask me about, I would go to a chiropractor sometime, and he was not a big fan of chiropractic. He just felt like that at the time, the cracking and the rapid manipulation was not safe, and B, that it was not effective. And of course, if there's any chiropractors here, they may disagree with that. But I did notice the last couple of times I've gone to the chiropractor, they don't do that hard stuff anymore. It's much more like the physical therapy. It's much softer. There's not the, I remember my son used to do the chiropractor in Texas, and he used to call this thing called the ring dinger. Gregory Johnson, I think was his name. He's still around, I don't know. But, he would do these videos where he would like take people and just go, you hear this loud crack. They don't do that. I don't think chiropractors do that much anymore because I think there may be some danger to it. And also, maybe there's evidence that type of manipulation is not as effective. So I don't know. I don't know how we got off on that tangent, but I sometimes do that. But bottom line is virtual telehealth for physical therapy. I don't think you wouldn't want them to do that exclusively is my answer. Jem says she's with physical and mental. That's helpful because, again, the more of your own doctors you see, the better it is. I think when you're just going to Social Security doctors, that's not good. And, you don't want to rely on a Social Security doctor to make an evaluation that would determine whether you're disabled or not. So, Kathy, I understand you worked 32 years. But again, the problem is if your insured status ran out 5 years ago, the recent knee problem, which may have put you over the top, won't help you because it could help for SSI, but not for SSDI. So I want to make that clear. You can always apply for SSI, but that's income and resource based. So if you have household income like a spouse or assets like money in the stock market or bank account over $2,000, that's a problem. And SSI kind of keeps you in poverty because anytime you work at offset, it's just not as good of a program, but maybe that's what you're limited to. Ali Tovar has been here before. Hello, Ali. I was told by my caseworker this morning after supposedly my case was in a quality review, my paycheck was big, won't receive it yet, April 1st, my first normal check. So it sounds like you've won. I don't know this business about big check not coming. That doesn't make any sense to me. I've seen people get big checks unless somebody else has to sign off on it. I don't know, but it sounds like you're in the home stretch. It sounds like you won. You're in the home stretch. That is really good. So congratulations on that. and just keep at it. They'll pay you eventually. Just hopefully it won't be too much longer. Dearborn Daily says, won your federal appeal. That's congratulations. Court next week with an ALJ. One orthopedic doctor didn't see me, but read my medical file and said I could stand for 2 hours. Is this bad? Well, I mean, it just kind of depends on a number of things. If you are 55 years old, 2 hour standing limit is a good thing, because that means that the light grids apply probably, and you are going to win. Standing 2 hours does not make you not disabled from work. It is a factor there. So I think it just depends on all the facts of your case. That is one factor. You can stand for 2 hours, but if you have to take unscheduled breaks every, 3 hours for 30 minutes, that is a problem. So it's part of the equation, the 2 hour standing. It's better if you were at 15 minutes, but I don't think this disqualifies you. But, I would depend on your attorney to give you some advice about what that means in terms of your particular case. When will be updated? No, I do not, Allie. I don't think that there's any way to know what the Social Security site, when it's updated, how often it's updated, what you can, your award letter. It's not going to be on the site. It's going to be mailed to you. My understanding is I don't think you get that on the site. You may see a summary of what is coming to you, but I don't think you will see the letter at this point. And again, that's one of the things that's needs to be fixed with Social Security. You should be able to get access to all the correspondence they send you online. Now you get maybe a summary of it. Look, I don't get those payment letters online. I mean, I have electronic access to your folder with all the correspondence, all that stuff. But once somebody's approved and I get an explanation of benefits letter, that is mailed to me in the postal mail. Okay, there's no way I can go in and look at it. If it gets lost, and it does sometimes, I don't know, and I have to try to get it to send it to me. What they should be doing, my opinion is, they should give people the option of getting correspondence from Social Security electronically or combination of both. I know, like, if you have stocks, or you have mutual funds, and you get these materials, prospectuses, or they have board elections, things like that. You can choose to get those things delivered to you electronically and avoid spending money on postage. And most people do that. Now, I realize that emails, things can go to spam, although you can set up rules to tell them anything from Social Security does not go to spam. But it would be nice to have the option of getting it all electronically, at the very least having a portal where you could go to see all the correspondence. They don't have that yet. This is, again, some of the dysfunction at Social Security. So you won't see it, Allie, at the on your my Social Security statement. You may see a note as to what is being said, but that's about it. So Michael was the one who was terminated. Says working part-time will not jeopardy. It depends on how much you earned. So working part-time is not inherently a problem, but if you're working part-time and earning $35 an hour and you go over to SGA, it is a problem. How long, and we're getting close to, let's see, we are now about 10 minutes left here. How long does a recon and appeal take? It just depends. It's right now, given all the nonsense going on at Social Security, 7 to 12 months on average, but I've seen it longer. Yes, Ali, it's just going to show the summary, I believe. Charles says, thanks for my advice. Well, thank you, Charles, for watching every week. Everybody's watching. Well, thank you very much. I really appreciate it. Very nice of you to say that. Thank you. And again, if you're so inclined, leave me a review. Leave the live stream a review. That would be really, really appreciated. Mark, how you doing? Mark, we're in the home stretch. Mark's here every week, one of my clients. Good to see you. Let's see. And let's see. Mr. Big, I sent in a case request. I'm not sure what that means. Red Horse Adventures. I missed 2 medical appointments with SSA. I was out of the country for a funeral, passport stamps. Yeah, I think that I would certainly let them know why you missed the appointments. It wasn't really your fault. So ask them to reschedule. Yes. Okay. All right. So Allie says that they told you you're not going to get your big check until the 1st of April. So it's another month. Um, Hopefully they send it. I mean, I've not heard of that, but okay, I'll accept that that's what they told you. But it'll be nice, certainly, when April comes and you have that check in your hands. I know. Actually, you know what? Even better than that check, set it up for direct deposit. You got a big check coming. You don't want to risk this being lost in the mail or having it stolen out of the mail. Set up direct deposit. You're much better off doing that, I think. Um, yeah, I think that Denials and Recon, but I think Mr. Big, I think you said you're younger, you're 40. Who would speedy trip to the judge? Yeah, I would agree. I think that you've got a good case, a bad case of MS, unfortunately, which is going to be, again, I think hopefully will be approved. Luca Brasi from The Godfather says he was a Steelers fan based on his picture. So it's going to be a thing of the past. Everybody disability says it'll be in the cheese line pretty soon, thanks to Trump. I think that may be a little extreme. The cheese line, I've heard the bread line, never heard of the cheese line. But I don't think it's going to go away. I think it just may change. But we'll see. We don't know. On stage 3, 59-year-old stroke victim, stroke in June of, well, that couldn't be possible. It's not June of 25, waiting for decision. So you mean maybe June of 24. I think that, though the fact that you're 59 had a stroke, those two factors tell me that's a pretty good case. Okay, again, Michael, I think it's the amount of money that you earned. Price Joyce says it's grossly unfair to pay back Medicare. You decided it was disabled, give me Medicare. I'm SSDI. Now, I don't know that, and I don't know the answer to this, but I think that Medicare goes on beyond disability for a certain period of time. I think so. I don't want to tell you you're going to have to pay back Medicare. I do not know. I just don't want to say that because that may not be the case at all. And again, an elder law attorney might be somebody who could answer that question. But I just, I don't know. I just don't know. Yolanda has osteoarthritis in the hands, being tested, osteopenia in my hips. How does this affect your case? Again, these are more things that would cause limitations to your functioning. If you have problems in your hands, it's going to affect grip and strength. Issues in your hips are going to may affect maybe walking or standing or lifting or weight. You might eliminate jobs where you're on scaffolds or unprotected heights, working on dangerous equipment, things like that, maybe even extremes of temperature. So I think these are all things that are going to help you a little bit. Great question, Michelle. If someone wins disability, they get Medicare? No, it is 24 months after your first payment. So if you're approved for disability in, let's say your onset date, you're approved is March 5th of 2025. The first payment, if an onset's March 5th, first 5 full months. So March doesn't count. April, May, June, July, August. First payment is September of 25. Medicare is going to be October of 27. That's when Medicare kicks in. So it's 2 years from the date of first payment. Okay, Kathy, again, I think you need to find out your date last insured, but I think that is going to be the problem because you haven't worked recently. Okay, so Red Horse had a hearing. Lawyer said, how many positions will be available with hand limitations? VE said 0. That would make the approved application. Judge quickly told the VE decision was not his to make. So, right, so you had a VE who obviously supported what you're saying. Realize the questions that the judge asked the VE are hypothetical questions. The judge may ask 5 questions. One question may get, here are jobs you could do. One question may get no jobs you could do. One question, maybe they change the exertional level from light to sedentary. It changes the answer. The answer is only as good as the question. So the VE does not make a decision because, it's going to depend on what the functional capacity the judge is assigned to your case. That is really the key there. All Motor says, I love what you do. Thank you very much. I appreciate it. And again, please leave me a review. I would really be grateful for that. And we got a couple more here. Then we got a lot more, but I can't go to all of them. Let's see. Okay, all motorists having a second hearing, spine damage, getting a spinal cord stimulator trials, LJ take certain medications, Spravato for major depression with suicidal ideation seriously. Yes, absolutely. I think that's, and what I do, if I have somebody who's on a medication that is somewhat rare, that is very powerful, that's going to cause side effects, I'll put in my brief what that medication is in a footnote. I don't always assume judges know. I'd never heard of, Spravato or esketamine. I've never heard of those drugs. So if I hadn't heard of it, it's possible the judge hasn't heard of it. Maybe the judge has, but I would put it in my brief, what it is and what is significant about it. Let's see. If you receive a letter from DDS Silver Monster asking you to call in, what can you expect to be asked, and how long will the call last? They're going to want to know what the past jobs were, what you did, the dates of employment. That's really what they're going to, and mainly what you did, because they're looking at having a vocational person look at it, determining, that let's say you were a stock clerk or something. Was that lifting 20 pounds? So you want to know, kind of in a range, how much were you lifting on a frequent basis, which is like, 10 times a day. Let's say how much on an occasional basis, 1 or 2 times a day. So you want to be specific about that. 10 pounds, 20 pounds, 50 pounds, that sort of thing. And then what you did. Were you a manager? Do you have hiring and firing authority? Things like that. It'll be a 10-minute call. Won't be very long. They're not trying to trick you. They're just trying to. I remember I talked to an adjudicator who said just because people thought the form's not well designed and they don't tell them anything. And so the form doesn't tell them much of anything. They just need to know more, because that can make a determination as to whether you have a job that has transferable skills or not. Is it a job that is was performed at the level the DOT says, or was it performed at a less demanding level? That's what they're really trying to do. How many people apply? That statistic is available. I don't know. Esoteric. I don't know. I'm sorry. I just don't know. But you can look that up. I suspect if you went to Google and said, how many people apply for Social Security disability every month or every year, it would tell you. Okay. The decision was made pending quality decision review. It probably means you were approved, and just quality review, they're just going to look to see, are there any earnings after onset, really. But that's probably a good sign there. Okay. Let's say you lose your hearing at the time of your hearing. You have 3 weeks left in your date less insured. Can you reapply and prove you became disabled the day after the decision because of the 2 weeks? Yes, you can. Yes, you can. It's going to be hard because your onset date is the day after the unfavorable decision. But, certainly if you can prove it, then go for it. But again, think about it. The judge just saw you maybe 2 months ago and decided you were not disabled, and, in the 2 weeks after your decision, because in theory, the decision, covers you whether you're disabled or not through the date of the decision. Obviously, something may have happened in the 30 to 60 days the decision was being reviewed and prepared. So maybe there's a 2-month gap where you have to argue you became disabled again. So it's possible, but it's going to be an uphill battle. Yes, it's possible. Okay. Harold got turned down before a judge at 61. Wow. Just maybe a tough judge. That's unusual. Okay. Great. You saw the videos. You applied your own, was approved. Excellent. I love to hear that. That's excellent. George says, hello, keep up the good work. Great. Vince, my friend owns rental properties. Long process to evict somebody. That's in Michigan, though. Yes, correct. Harold is in Georgia. Well, there are some judges that wouldn't surprise me. So I hear you. All right, I got time for a couple more here. Claire has been at Initials since January of 24, filled out the function report in November. How long does it take to get a decision? You should be getting close. There's no specific time. you should be getting close. Hopefully the next 2, 3, 4 months. Hey, Pat, Cajun Sunshine. Have you ever had trigeminal neuralgia case untreatable major depression? I've not had great luck, quite frankly, with trigeminal neuralgia. That's where you have a nerve in your face that gets compressed and causes a great deal of pain. Don't have a lot of now. You've got the major depression, the PTSD, anxiety. You know, I don't know why those cases have not been approved. Maybe I've had 2 or 3 of them, and maybe I just got bad judges. I remember I had one where I had a guy who was in the military, and when he was, I guess, holding a gun, his sergeant comes up to him, takes the gun, smashes him in the face with it, and that's where he developed it. It's one of those conditions that you can't really image it. So for some reason, it just doesn't seem to move the meter. So, but again, I have a very small statistical study. So I just think that, if you have doctors and neurologists that support you, and the neurologist says that your level of discomfort, pain makes it hard for you to focus and concentrate, it would leave you without the capacity to be reliable for 3 hours a day, twice a week or something like that. And you've got a psychologist or psychiatrist that has you on medications that says your mental health status is not sufficient to allow for competitive work, then you got a shot at winning. So hopefully that will be the case for you. Okay, we are now at 2 hours. We had a great turnout tonight, over 200 people, which I really appreciate. Thank you all very much for tuning in. We'll see you next week. I've got some people lined up coming up, and we'll have some special guests. I know I've got a judge coming up. I'm trying to get him pinned down on a time. I've got a couple of appellate attorneys who want to come on, a couple of other attorneys who want to come on. And so we're going to hopefully have some fun with that. But I know everybody's really concerned. Just let me reiterate, everybody's concerned about our benefits going to stop. I promise you, if I hear there's going to be any interruption, that's even a chance, I will let you know. So far, that is just rumors. So don't buy into rumors. Despite what Mr. O'Malley says, don't buy into rumors. I don't think that's going to happen, but we will watch it very closely. So again, thank you all for tuning in, and we'll see you next Wednesday. Take care.